POCSO Act 2012 and analysis. On 26 August 2016, an online complaint box for reporting child sexual abuse, the POCSO e-box, was launched by the Minister for Women and Child Development, Srimati Maneka Sanjay Gandhi, in New Delhi. Protection of Children from Sexual Offences, or POCSO e-box, is an online complaint management system for easy and direct reporting of sexual offences against children and timely action against the offender under the POCSO Act 2012. Speaking on the occasion, Srimati Maneka Gandhi said that the idea of an e-box came out of a police initiative in which physical complaint boxes were placed in schools. The e-box will make it possible to implement it on a large scale throughout the country. A large number of incidents of abuse are against close relatives, and so they get pushed under the carpet. E-box is very simple to operate and will help to maintain the confidentiality of the complaint. Now, before getting into the analysis of the provisions of POCSO Act and their effectiveness, let us first try to understand the significance of the issue from the point of civil services examination. Significance. The issue has its significance both in terms of A. Challenges witnessed in Indian society at present, and B. The policy initiatives towards social justice. One is a part of GS Men's Paper 1 and the other of GS Men's Paper 2 respectively. Now let us look into the provisions of the Act and then analyze the effect it may have in addressing the issue. The provisions. India is home to the largest child population in the world, with almost 42% of the total population under 18 years of age. Needless to say, the health and security of the country's children is integral to any vision for its progress and development. One of the issues marring this vision for the country's future generation is the evil of child sexual abuse, or CSA. Statistics released by the National Crime Records Bureau reveal that there has been a steady increase in sexual crimes against children. According to a study conducted by the Ministry of Women and Child Development in 2007, over half of the children surveyed reported having faced some forms of sexual abuse, with their suffering exacerbated by the lack of specific legislations to provide remedies for these crimes. While rape is considered a serious offense under the Indian Penal Code, the law was deficient in recognizing and punishing other sexual offenses such as sexual harassment, stalking, and child pornography, for which prosecutors had to rely on imprecise provisions such as outraging the modesty of a woman. The Ministry of Women and Child Development, recognizing that the problem of child sexual abuse needs to be addressed through less ambiguous and more stringent legal provisions, championed the introduction of a specific law to address this offense. The POCSO Act was therefore formulated in order to effectively address the heinous crimes of child sexual abuse and sexual exploitation of children. The Protection of Children from Sexual Offences Act 2012 received the President's assent on 19th June 2012 and was notified in the Gazette of India on 20th June 2012. The Act defines a child as any person below 18 years of age and regards the best interests and well-being of the child as being of paramount importance at every stage, to ensure the healthy physical, emotional, intellectual, and social development of the child. It defines different forms of sexual abuse, including penetrative and non-penetrative assault, as well as sexual harassment and pornography, and deems a sexual assault to be aggravated under certain circumstances, such as when the abused child is mentally ill, or when the abuse is committed by a person in a position of trust or authority vis-a-vis the child, like a family member, police officer, teacher, or doctor. People who traffic children for sexual purposes are also punishable under the provisions relating to abetment in the Act. The Act prescribes stringent punishment graded as per the gravity of the offence, with a maximum term of rigorous imprisonment for life and fine. In keeping with the best international child protection standards, the Act also provides for mandatory reporting of sexual offences. This casts a legal duty upon a person who has knowledge that a child has been sexually abused to report the offence. If he fails to do so, he may be punished with 6 months imprisonment and/or a fine. Thus, a teacher who is aware that one of her students has been sexually abused by a colleague is legally obliged to bring the matter to the attention of the authorities. The Act, on the other hand, also prescribes punishment for a person if he provides false information with the intention to defame any person, including the child. The Act also casts the police in the role of a child protector during the investigation process. Thus, the police personnel receiving a report of sexual abuse of a child are given the responsibility of making urgent arrangements for the care and protection of the child, such as obtaining the emergency medical treatment for the child and placing the child in a shelter home. should the need arise. The police are also required to bring the matter to the attention of the Child Welfare Committee or CWC within 24 hours of receiving the report. So, the CWC may then proceed where required to make further arrangements for the safety and security of the child. The Act also makes provisions for the medical examination of the child designed to cause as little distress as possible. The examination is to be carried out in the presence of the parents or other person whom the child trusts, and in the case of a female child, by a female doctor. The Act further makes provisions for avoiding the re-victimization of the child at the hands of the judicial system. It provides for special courts that conduct the trial in camera and without revealing the identity of the child in a manner that is as child-friendly as possible. Hence, the child may have a parent or other trusted person present at the time of testifying and can call for assistance from an interpreter, special educator, or other professional while giving evidence. Further, the child is not to be recalled repeatedly to testify in court and may testify through video link rather than in the intimidating environment of a courtroom. Above all, the Act stipulates that a case of child sexual abuse must be disposed of within 1 year from the date the offense is reported. Another important provision in the Act is that it provides for special court to determine the amount of compensation to be paid to a child who has been sexually abused so that this money can be used for the child's medical treatment and rehabilitation. Now, let us analyze the impact that this law may have along with the critical aspects of the law. An analysis. The Constitution of India recognizes the vulnerable position of children and their right to protection. The framers of the Constitution of India were also aware of their responsibility towards children. This awareness is reflected in the constitutional provisions which are intended for protecting the rights of the children. It guarantees in Article 15 special attention to children through necessary and special laws and policies to safeguard their rights. The right to equality, protection of life, personal liberty, and right against exploitation are enshrined in Article 14, 15, 15.3, 19.1a, 21, 21a, 23, 24, 29e, and 29f of the Constitution and India's commitment to the protection, safety, security, and well-being of all its citizens. In spite of all this, children are still at risk. They are exposed to most inhuman cruelties and endure the worst forms of abuse. India, with 1.29 billion people, out of which children represents 42% of the total population. CSA remains a taboo, but it's a very real problem in India. And the situation is aided by the absence of effective legislation and the silence that surrounds the offense. Majority of the people feel this is a largely Western problem and does not happen in India. According to the NCRB records, pendency rates for child rape cases have actually increased from 20,594 in 2010 to 37,519 in 2014, a massive increase of about 84%. This pendency persists in the face of increased reporting. While the judicial process dawdles along, 8 cases of child sexual abuse continues to be reported every day. The number of registered child rapes rose to 151% from 5,484 in 2009 to 13,766 in 2014. Over the last 2 years, 6,816 cases that were registered as FIR under the POCSO Act, only 555 made it to the court and 166 convictions have been made, while 389 accused have been acquitted. The conviction rate under the Act therefore is a paltry 2.4%. According to WHO, 1 in every 4 girls and 1 in every 7 boys in the world are sexually abused. Reliable estimates are hard to come since this is a furtive form of abuse, often causing victims to suffer in dark and claustrophobic silence. To find out the extent of child abuse in India, the first ever national study on child abuse was conducted by the Ministry of Women and Child Development, covering 12,447 children, 2,324 young adults, and 2,449 stakeholders across 13 states. In 2007, it published the report as Study on Child Abuse, India 2007. The survey covered different forms of child abuse, that is physical, sexual, and emotional, as well as female child neglect in 5 evidence groups, namely children in a family environment, children in school, children at work, children on the streets, and children in institutions. This study brought out some shocking facts, and its main findings in relation with sexual abuse are: sexual abuse was reported by 53.22% children. Among them, 52.94% were boys and 47.06% were girls. 21.09% of child respondents faced severe forms of sexual abuse. 5.69% had been sexually assaulted, and 50.76% reported other forms of sexual abuse. AP, Assam, Bihar, and Delhi reported the highest percentages of sexual abuse among both sexes, as well as the highest incidence of sexual assaults. The highest incident of sexual assault was reported in children on street, at work, and in institutional care. 50% abusers were known to the children or in a position of trust and responsibility. Most children did not report the matter to anyone. More than 53% children reported facing one or more forms of sexual abuse, and boys were equally at risk as girls. Almost 22% faced severe sexual abuse, 6% sexually assaulted. 50% of sexual offenders were known to the victim or were in positions of trust, such as family members, close relatives, friends, or neighbors. 5 to 12 years age group faced higher levels of abuse, largely unreported. Severest sexual abuse in the age group of 11 to 16 years, 73% of sexual abuse victims were in age group of 11 to 18 years. The age-wise distribution showed that though the abuse started at the age of 5, it gained momentum 10 years onwards, peaking at 12 to 15 years and then starting to decline. Another study on child abuse in Kolkata, Elan and NGO found that 4 out of 10 boys faced sexual harassment in schools. Generally, the age of maximum abuse is between 9 to 12 years. The national study found that the abuse gained momentum at the age of 10 and peaked between 12 to 15. In Indian legal system, child has been defined differently in the various laws pertaining to the children, and the age of an individual in order to be determined as a child is not uniformly defined. Therefore, it offers various gaps in the legal procedures which are used by the guilty to escape punishment. According to the Convention on Rights of the Child, Article 1 defines the child as every human being below the age of 18 years, unless under the law applicable to the child majority is attained earlier. The IPC defines the child as being 12 years of age, whereas the Indian Traffic Prevention Act 1956 defines a minor as a person who has completed the age of 16 years but not 18 years. Section 376 of IPC, dealing with punishment for rape, defines the age of consent to be 16 years of age, whereas Section 82 and 83 of the IPC states that nothing is an offence done by a child under 7 years and further under 12 years, till he has attained sufficient maturity of understanding the nature of the act and the consequences of his conduct on that occasion. There also exists a differential definition for boys and girls as seen in the Juvenile Justice Act, which defines a male minor as being below 16 years and a female minor as being below 18 years of age. In this light, if we look into the provisions as has been mentioned in the legislation, POCSO Act 2012 is an excellent legislation, and it recognizes almost every known form of sexual abuse against children as punishable offense. However, several issues still remain to be answered. The Act remains an unimplemented, unknown to the most, and beyond knowledge or information of those who apply it. State authorities, police, and educational institutions have done little to spread awareness of POCSO. The result is obvious. Ignorance is bliss. Those responsible for the implementation of POCSO do not even know that any person or institution who fails to report the commission of an offence under POCSO or fails to record such an offence is also liable for punishment under Section 21 of POCSO. Shockingly, in an unfortunate but one of the most infamous rape cases, the Delhi police included the provisions of POCSO to the FIR reported after 2 days of the filing of the FIR in April 2013. Most child sexual abuse cases are not booked under POCSO. Child sex offenders get away despite of stringent law. Indoctrination, training, familiarization, and actual application by police officers and other stakeholders still remains a far cry. Now, the passing of the statutory law is more than significant by a variety of reasons. It defines exclusively the crime of sexual offences against children and fulfills the mandatory obligations of India as a signatory of the United Nations Convention on Rights of the Child, acceded on December 11, 1992. For monitoring and implementation of provisions of POCSO, the Act enjoins that the National Commission and State Commissions for Protection of Child Rights, constituted under the Commissions for Protection of Child Rights Act 2005, shall ensure the effective carrying out of provisions of POCSO. The Supreme Court, in hard-hitting directions on 7 February 2013, has directed all states to ensure the effective carrying out of the provisions of POCSO. The Supreme Court, in another direction on the same day, has directed all states to ensure that the regulatory and monitoring bodies are constituted and made functional. Upon the National Commission for Protection of Child Rights petitioning the Punjab and Haryana High Court in a path-breaking judgment rendered on 9th April 2013, it has been directed that the state of Punjab and Haryana, as well as the Union Territory of Chandigarh, shall ensure that the state commissions for protection of child rights, headed by a chairperson who should be a person who has been a judge of High Court, shall become fully functional by appointing chairpersons and 6 members appointed through a transparent selection process. The High Court has further directed mandatory registration of all children homes, constitution and notification of children's court, and appointment of special public prosecutors, besides constituting a proper selection committee to make further selections of various committees to be set up for child welfare. Hence, the entire machinery of monitoring child rights has been galvanized. A further direction has been issued that the National Commission and State Commissions shall start discharging their functions under POCSO for implementing its provisions and modules, training programs for sensitizing all stakeholders on child rights, and for dealing with cases in children's court be also initiated in the Chandigarh Judicial Academy. It is now for the state governments to implement this beneficial mandate and create an effective machinery to check heinous crimes of gross sexual abuse against children by enlightening all concerned about it. It is the duty of the state to know, perform its obligations for the welfare of the society. The Justice Verma Committee report, in one of its conclusions on child sexual abuse, holds there is urgent need to audit the performance of all institutions of governance and law and order. It is indeed necessary that we must now have external social audit for the sake of transparency. The committee also wished to make it clear that every case of a missing child must be registered as FIR. The committee further makes suggestions of constituting an oversight mechanism through the High Court, special training-based programs, sensitizing officials on sexual abuse of children, and strict implementation of provisions of various enactments of child laws. Summing up, we need to consolidate our efforts and focus our energies on existing laws and not look to amending more laws and making still further newer laws, alien to our culture, society, habits, lifestyle, and harsh realities of the common man. Insofar as child sex abuse is concerned, POCSO is a wholesome law. The government must create the machinery to implement it and educate its officers, besides all stakeholders, on what it contains. The remedy to handle the public outcry is by implementing POCSO. All child offenders must be charged, tried, and punished in accordance with POCSO expeditiously. Speedy, stringent, and relentless pursuit of POCSO is the remedy and a possible cure. The state must not waste its time in exploring alternatives when the answer exists in a law made by the Parliament for these special offences against children, the most vulnerable section of the society. Today's children are tomorrow's future. Let us protect them. The laudable endeavour of late Justice Verma must find implementation. Thank you.